What's a preliminary hearing? Why does my complaint say felony, and in some cases, complaint for preliminary examination? Hi, my name is Joe Fagan of Fagan, Fagan & Davis. We're a criminal defense firm. We deal with this question on a regular basis. When you're arrested and charged, if your case is a misdemeanor, the body of the complaint up at the left top will say misdemeanor complaint. If you're charged with a felony, it will say the word felony, or it will say felony complaint for preliminary examination. A preliminary examination is kind of a nice way of saying a preliminary hearing. A preliminary hearing is a hearing to determine two things and two things only, not guilt or innocence. First, did a crime occur? Is the conduct complained of in the complaint sufficient to meet the elements of the offense charged? And second, are you, the defendant, involved in the commission of the crime to the extent that you should stand prosecution? The burden of going forward and the burden of proof at this point is on the prosecution, but it's a relatively low burden. It is not beyond a reasonable doubt. It is probable cause. That is there enough to go forward to the next step of the case? The next step of the case would be the formal charge, the felony charge, which is the charge that they have to prove beyond a reasonable doubt. During a preliminary hearing, the prosecution has to produce evidence. That's the burden of going forward. They can do that by summary. That is, they can bring in an officer or another witness, a single witness, to testify to what other people told. We can cross-examine. We can challenge that case. How far can we go in challenging the state's case during a preliminary hearing? The answer to that is the sound discretion of the trial judge, the judge who's hearing the preliminary hearing. He can cut it off quite short if he is convinced at that point, or at some point, that there's enough evidence to hold you to trial and move the case along. But sometimes a judge will let you go quite far, depending on the quality of the evidence, depending on the quality of the witness and the credibility of the witness. Sometimes you can really make a difference in the outcome of the case by going forward and really attacking at that point. In any case, if there is a finding of probable cause, the judge has made his mind up that there's enough evidence to hold you to trial to the next step of the case. That is where the arraignment occurs, where the formal charging instrument is filed against you. That's the document that can end up in a conviction. Remember, it isn't guilt or innocence at this point. It's whether there is probable cause to move on to the next step. It's designed to really weed out the weakest, most questionable cases. Thank you for joining me. My name is Joe Fagan of Fagan, Fagan & Davis. We're a criminal defense firm here in Illinois. If you are facing felony charges here in Illinois, give us a call at the number listed below. We'll be happy to help you. We'll be happy to talk to you.